Hello, my dear Elpis friends. How are you? Call for articles, number 12, Elpis View or Review. Artificial Intelligence Regulation in a Comparative Perspective. Being a man of another century, as my daughter always points out, I begin this approach to artificial intelligence in the law using some reflections on a book recently published by Bruno Patinho, Submersion. When the author realizes that something has happened, something has changed, the world of limited supply led us to believe in the unlimited capacity of our brains to choose. The age of infinite supply now confronts us with the reality of our personal limits. We weren't that great. Now it is the time of the submersion. In my view, this submersion is caused by two main contemporary problems of the AI society. The question of choice, so many possibilities, so reduced choice. That is an illusion of the choice that is nowadays the main question of freedom or liberty. The question of control, that comes from the power of the algorithms in politics, in law, in society, and conducts to the need to control AI. Let's analyze now, using a realistic approach, some of the consequences of AI and new technologies in the field of public law. 1. Technological changes do have drastic consequences in the action of public authorities, of the legislative, the administrative, or the judiciary powers. There is the work done by the machines, acted by man, the replacement of paper documents by digital ones, the need to find out new AI solutions to procedures and processes in the decision-making process. In terms of the organization of the services, there is also a problem that should be considered, that is the mass productions of court decisions, procedures, appeals. And the same happens with the mass production of deputies, administrative officers, lawyers, judges. This leads Balkin to question whether the government should adopt a factory model and whether it is possible to rationalize legal work without losing the human dimension. 2. Information availability. We are facing an indispensable tool for law actors and public services. As a matter of fact, the new technologies simplify the tasks of lawyers, providing an easy and reliable way to find status, law, regulations, court decisions, an easy way to make data research, information treatment. In a nutshell, we may say that we face a change in the behavior of all the law actors, judges, administration, lawyers, offices. One could also pose the question whether is still there a place for law theory and philosophy, or if too much information could not come to the result of too less law. How to avoid that the banalization of the machines transforms their users into flesh and blood machines. 3. Specific legal problems arise from the use of AI and new technologies in each one of the law fields. Just to point out some of the most relevant ones in public law, we can talk about fundamental rights. There is the right of digital self-determination, the right to access, to amend, to erase data, to be forgotten. In administrative law, the mass-produced administrative decisions, the authorizations and the limits for automation, the digital procedures, the algorithms, and their administrative and judiciary control, judicial ways to control digital decisions. But many other problems arise also in private law, from liability of AI decisions to replacement of labors by the machines, from AI data protection to civil security. More and more fields of privacy and freedom of persons are being invaded by AI. 4. Specific problems of law teaching. The use of AI and new technologies is also relevant for law teaching and learning. Pedagogical tools like the PowerPoint, the web pages, the blogs, the video reviews, the long-distance lectures and conferences, the educational gaming, the electronic quizzes became well known nowadays in all faculties and law schools. More specifically, AI simplifies research tasks and the writing of scientific papers. However, the use of tools such as ChatGPT may not always be able to provide the most appropriate answers, tending to invent them in these situations, and can also be misused, favoring academic fraud. It is therefore a challenge for modern pedagogy to find the best way to enhance the use of AI, inside or outside the classroom, while minimizing its flaws and drawbacks. All that shows very well the importance of a pedagogical approach, more directed to the law problem than to the theoretical study of the doctrine, and more interested in discovering how to do it instead of how to solve it, as Wenger Kramer Frank Westphalen pointed out. What do we want you to do? The important thing is to choose a topic of your law field related to the theme artificial intelligence regulation in a comparative perspective. Then prepare a V article and send it to us. That will put it in our web review. And by the end of the day, we'll have a diversified and comprehensive global, European, and comparative law review on AI. Deadline for the 12th volume of our viewer review would be the end of June, and we plan to have it published by the beginning of July. Just do it. Send us a video, please. Bye. That's all, folks.